Hello, everyone, and thank you for joining us for our program, Nuts and Bolts of Virginia Solar and Energy Storage Siting Agreements. My name is Brad Nowak. I'm a partner and co-chair of the Energy Practice Group at Mullen, based in its Tysons, Virginia office. Our Renewable Energy Group has a full-service team of over 30 attorneys who help clients navigate all aspects of the development, permitting, financing, construction, operation, and sale of renewable energy projects. One of the most frequent questions our team gets is about solar and energy storage siting agreements. Questions such as, what are they? How can they be utilized? And what are some of the common terms and payment amounts? So to help answer those questions, I'm very pleased to be joined this morning by my colleague, Steve Romine. Steve is a partner in our real estate and land use practice group based in our Virginia Beach office and a member of our renewable energy team. Steve has 44 years of experience assisting clients on a variety of real estate matters. In the renewable energy space, Steve has extensive experience advising clients in local permitting, Virginia siting agreement statute, and in drafting and negotiating terms and conditions of siting agreements. In addition to Steve, our land use team has 8 other professionals in Virginia and North Carolina, and our full land use team has extensive experience working on local permitting of solar and energy storage projects in 48 localities all across Virginia. Before we kick off today's program, I have just a few housekeeping items to go over. At any point during today's presentation, you may submit questions by using the Q&A button at the bottom of your screen. We'll answer questions at the end of the presentation if we have time. If we don't have time, we will certainly contact you directly afterward. If you're having any audio or technical problems, you can use that same Q&A button and someone will help us get those resolved. And finally, this PowerPoint presentation will be emailed to everyone afterward, so you'll get a copy of that. So now let me pass the program to Steve to cover the agenda and begin his presentation.
Thank you, Brad. Good morning. It's a privilege to be with you this morning. And as some of you may recall, we did a webinar back in June of 2022 that addressed nuts and bolts of land use issues with respect to solar and battery projects. 2 years later, we're back again, and today we're going to drill down into siting agreements. And I'm going to give you a brief overview and a roadmap of what we hope to cover in the next 25 minutes. In front of you, you see an agenda. So we're going to talk about some siting agreement legislation first because it's important to have that context. Next, we're going to talk about some process issues. Next slide, please. And then we're going to talk about some substantive issues, which include various provisions that are included in siting agreements, and then some of the payment structure that we see there. We'll also conclude with a look forward to what we might be able to contemplate for the General Assembly in 2025. Next slide, please. Next slide. So let's take a look at the relevant Virginia statutes that relate to siting agreements. I've highlighted 7 on your screen, and I'm not going to read them to you, but I am going to reference them as I go through the presentation this morning. The first one on there is 15.22316.7. That provision of the code outlines the notice requirements and the terms for a siting agreement. It was adopted in 2021. The next section of that same code is the powers of the host localities, and it outlines various powers, and there's some provisions in there we'll look at as well. And then the following section in that same statute is the effect of the siting agreement and some of the impacts that it has. I also cited in this list 2288.2, 15.2, 2288.8. This provision is a separate ordinance that allows the locality to condition a project and obtain a dedication of property or substantial cash payments as long as those payments are reasonably related to the project. So you'll see, just for context, within some siting agreements, they reference 2316.7 as sort of the authorizing language for those payments. Others will reference 2288.8. And under either and both, they do provide for that authority. I also put up here 15.2, 2229. This is the general section of the code that allows for the amendment of the comp plan. And then 2232H is a new provision in the substantial accord statute, which we'll talk a little bit as well, because it does have an impact on siting agreements, and then 58.1, 2636, which is the revenue share ordinance. So these various statutes are going to inform and impact how we interpret and how we draft our siting agreements. So I'll refer to them throughout this presentation. Next slide, please. Let's talk a little bit about some of the process questions that arise within siting agreements. One of the curious things I've seen out there is this thought that somehow providing an incentive for a project by payment of money is somehow inappropriate, that it's unseemly, it amounts to bribery. I've heard that from citizens. I've heard that from several localities. Let me just say straight up front, 2316.7 is mandatory. It states that if you're going to locate a project, either a solar project or a battery project in a locality, you literally have to give them notice and ask to meet and to negotiate the siting agreement. So it's pretty clear under the code that it's a requirement, certainly not something that's inappropriate and something that's not necessary. So if you intend to develop a project in a locality, you have to give that notice. Now, under 2316.7, Section B, it outlines what it is a siting agreement is trying to achieve. And it states in there that it's to mitigate impacts and to provide financial compensation to the locality. And that was adopted by the General Assembly because there was a need to incent these localities to want to site projects in their locality. Under the financial compensation section of 2316.7B, it outlines a list of categories where you can allocate the funds. That by and large is not an exhaustive list. There is some flexibility, we believe, in how counties allocate their monies that could be paid under a siting agreement. Also, remember 2288.8 says that you can do a cash proffer as long as it's reasonably related to the project. One of those things, as an example, could be where you could fund some EMS facilities or equipment because there's a risk of fire, let's say, to a battery project. And so that would be reasonably related to the project, and therefore those monies could be spent to buy a fire truck or other things like that. Let's continue on. So another question that arises is the approval coordination. And people get kind of really wrapped around the axle in this area a little bit, and I hope we can provide a little clarity today. Under 2316.9 of the code, it says the developer may file for appropriate land use approvals at or after the time it submits its siting agreement notice. So what it really contemplates is that somewhat contemporaneously with the filing of your application for land use approvals, that you send that notice to the locality. And I've seen kind of the best practices is to send that notice at the time you submit your application, and then you try to keep that negotiation on a parallel path to your use approvals. Now, this is where things get a little wonky. Let me just talk about the land use approvals separately for a minute here, because I think people tend to get the two mixed up a little bit. So the land use approvals have to go through at least 3 steps. You file the application, the staff or the third-party consultant issues a recommendation, and then it's set for a public hearing at the Planning Commission. The Planning Commission's job is to review the application for compliance with land use principles and ordinances of the locality. It really is not their job to get into politics or into financial incentives. Second, and thirdly, that application for land use approval, whether it's a rezoning, a use permit, or something else, would then go to the Board of Supervisors for its approval. So again, you have 2 public hearings that would occur with the land use process. In a rezoning, you would offer proffers. In a use permit scenario, the locality would impose conditions. And hopefully you'd be able to negotiate those conditions and have some feedback as you look at the type of conditions that will be imposed on your project. Some of them go up to 45 to 50 to 60 to 100 conditions, depending on the locality. Contrast that with a siting agreement. Siting agreement's only required to be adopted by the governing body, which is normally the Board of Supervisors in the locality. So there's one public hearing that has to be conducted for the siting agreement, and then that's approved in a single step to the board. So I'm sort of setting the table a little bit for some other issues I'm going to address on how things get a little confused. You see this quote here at the bottom from a resolution from Rockingham County, and they basically passed a resolution saying that to enter into the agreement prior to the public debate on the legislative land use process is inappropriate and biases the legislative process. I think most people or a lot of localities would probably agree with this to some degree. I think the concern is there is an optic that if the siting agreement were to get approved ahead of the land use approvals, that somehow there wasn't a clear debate and conversation about the appropriateness of the land use approval. So most all localities I've dealt with are always going to run the land use approvals through and make a decision on that before they adopt the siting agreement. However, it doesn't mean they can't, on a parallel path, be negotiating and talking about the siting agreement at the same time. Next slide, please. So keep in mind, the siting agreement is a contract. It is a financial contract between the developer and the governing body. So the first thing you have to ask yourself is, who has the authority to negotiate and enter into that contract? And essentially, it is the governing body. And that will reveal itself differently depending on the locality you're in. Some localities will have the county administrator take the lead. Some will have the county attorney and the county administrator together with a member of the board. However, whatever the executive group is that you're dealing with, that's where I try to keep my focus on the siting agreement, because ultimately they're the people that have to approve it. I'll talk in a minute about some localities that allow the siting agreement to go to the planning commission, which I think is just a mistake and creates a lot of problems. The second thing I'm highlighting, there's a lot of other issues in the siting agreement provisions, but the other one is confidentiality. Some of the siting agreements you review will have confidentiality provisions in it. The economics of your transaction, the proprietary nature of stuff you're doing, you might want to keep out of the public domain. That is a little difficult with FOIA, but you can kind of navigate that through. But I really am a strong advocate of keeping the siting agreement within a small group of people that are authorized to negotiate, and that we keep those terms confidential as long as possible. Ultimately, it will become a document that people can see the numbers and the provisions, particularly when you get to the public hearing and the approval. But if you do that too early, you get too many cooks in the kitchen and things can get off track. So let's talk about D, which I've said, appropriate proceedings. So again, the zoning approval process is a separate process. It only deals with land use, and that's what the Planning Commission is supposed to do. When you put a siting agreement in the land use process, things get confused because you have a lot of people saying, well, I want this in my district, or I think we should spend the money this way or that way. The allocation of the money certainly is something the locality can handle kind of behind the curtain, but I don't think it should be something that is openly negotiated up front and can create a lot of problems. Let's talk briefly about the role of the comprehensive plan. So each locality is required to adopt a comprehensive plan, and is required to update that plan every 5 years. The comprehensive plan is not statute, it is a guide, and it informs developers as to whether an appropriate piece of property is consistent with the plan that the county has for its development. Now, what's happened with the comprehensive plan, because solar and battery ordinances have come along the last 4 years, is many comprehensive plans didn't have a solar element in it. And so part of the process of updating these plans is to include areas that might be appropriate for development and provisions and elements that would inform a developer as to what they need to do with respect to the comprehensive plan. Now, keep in mind, section 2232 is the substantial accord process that is also mandated by statute. And the statute basically says that under the 2232 process, that the general approximate location, character, and extent of a feature must be shown on the plan, and that no public utility can be constructed until that's identified and shown on that plan. So what you have is this process where the Planning Commission evaluates an application to see if the county's plan is met, if that application is consistent with it. And that's where we get the substantial accord determination. That determination is rested in or vested in the Planning Commission. So if you end up in a 2232 and you go to the Planning Commission and they say that your project's not consistent with their comprehensive plan, then sometimes that can stop the deal right in its track at that point. However, you have a right to appeal that to the board, and then the board could overturn that and you can get back on track. And so why is that important? Because historically, on projects of this nature that have to have a 2232 review, it is the first step where there is input from the locality and from the public on your project. And so many times it's such a narrow analysis, you don't get a chance to get out of the box to talk about all the attributes and benefits of your project in a broader sense, because they're looking at this in a narrow analysis. And so the question becomes is, can you get to the 2232 favorably, or do you have to do an appeal? If you get through the 2232 and then you move on, then you can process your zoning or your land use approvals. Now, under section 2316.9 of this new ordinance I mentioned previously, there is a provision there that allows a bypass of the 2232 review if you enter into a siting agreement. So section C basically says that approval of the siting agreement shall deem the project in substantial accord. Now, if you've done a lot of this like I have over the years, you're always looking at the comp plan to find support for your project, and then people that want to defeat the project will find provisions that say we want to preserve agricultural land, and so there's debate as to whether your project is in substantial accord or not. It depends on whether they're viewing your project favorably or not as to whether you get the thumbs up on that. So I want to belabor that. It is important. We can come back to that in the questions if you have some. So let's go to the next slide, please. So we talked about the process issues. I want to spend a little time on some content. So if you look at content, siting agreements are a contract, as I said earlier. And so there's going to be boilerplate and there's going to be special provisions, and they're different forms. They vary from locality to locality, and I've looked at a lot of them, and there are some consistent provisions that you'll find in all the siting agreements. The main one is the revenue structure and pricing. And I should have said earlier in my presentation that we're really not going to talk about taxes and M&T calculations today, because that's sort of a whole another subject with a lot of variations to them. But just for today, we're going to be talking about the primary provisions in the siting agreement, the most significant of which is the revenue structure and the pricing. So if you back off a little bit, you think about the revenue streams that are coming to the locality. The first thing that they look at is the real estate tax for the property that you are developing will increase, whether it's going from undeveloped land or ag to a higher district. There is some modicum or increment of increased value to the locality. So that's what I call one bucket of revenue that's coming to the locality. Then we go to the siting agreement to provide some additional financial incentives. And what you typically see is what I say is an initial one-time kind of upfront payment. And then you see a schedule of payments over the life of the project. the question always becomes, well, what is the standard out in the industry? What are people paying at this point in time, and how does that work? Well, that varies as well. But for that initial upfront payment, I've seen from about $13,000 a megawatt all the way up to $45,000 a megawatt. And we'll talk a little bit more about maybe why that occurs. And then the scheduled payments over the life of the project typically are this M&T tax, in quotes, equivalent, that is payable over the life of the project based on the value of the equipment and the machines. And that really only applies if a revenue share ordinance has not been adopted. And I'll talk about that a little more in a minute. So when you're looking at the revenue structure and pricing, the batteries projects are typically less acreage, may or may not, probably less dollar investment, but because the impacts are lower, we've been successful in negotiating sort of a lower upfront payment. Now, obviously, they're also utilizing the revenue share on a megawatt basis for battery over the scheduled payments, but the upfront payments I've found to be significantly lower, as much as really about $4,000 a megawatt. Now, that may vary. I haven't looked at a lot of those, but the few ones I've looked at have been substantially less than the solar projects. Looking at the M&T tax issue just for a brief second, you cannot waive the tax. The locality can't say, we're not going to collect the tax, you're not going to waive it. Now, obviously, there's ways the tax can be collected and abated and other things that are in the formula. But what we're finding in the setting agreement is on the schedule payments over the life of the project, there's a concern that if there are abatement to those revenue streams and they go down, that somehow the county is not going to get full benefit. So there's a lot of formulas out there that are being utilized to do a makeup if in year 20 of the project, all of a sudden, the project is paying less than what would have otherwise be paid, let's say, under the revenue share ordinance. So there's this differential provision that's allowed by formula. Don't confuse the fact that there's been a waiver of the tax or something like that. So that is something we typically see as well. If we look at the revenue share ordinance, the legislation in 58.12636 provides that it's payable for $1,400 a megawatt, and then there's an escalator in it as well, but that's payable throughout the project. Now, a lot of localities have not adopted revenue share. In order to opt into that, they have to adopt a local ordinance and elect to do that. And it's effectively replaces that M&T stream. So you have to look at the holistic view of the document and the payment streams and what the project can bear in the way of payments. Let's look at several provisions that I've highlighted here that are in the siting agreement that might be of interest. Cross default, a lot of localities want to cross default between the conditions and the CUP and the setting agreement. Obviously, if that's in there, just keep in mind, if there's a breach of one, there'll be a breach of the other. A very important issue, the payment timing. We've seen the structure of the initial payment as early as after the issuance of a use permit. This all goes to the concept of de-risking your project. If your project still has a lot of risk in it, you may not want to pay those payments early because you don't know if you still can develop. There is a provision in most setting agreements that's a provision that's called no obligation to develop clause. And what that says, if we don't ultimately get approvals and can't develop, we have no obligation to pay. If you pay an upfront payment, let's say within 90 days of your use permit, all of a sudden that obligation, no obligation to develop clause is kind of gutted because you've now paid a substantial amount of money up front and you still have risk in the project. You may never get to develop. And that is an issue and a concern you definitely got to keep an eye on. I put in here adoption sequence again, just to reiterate, the use approvals should go first and go through that process. You can, on a parallel path, negotiate the setting agreement. And then at the end, hopefully you'll get your use approval or your conditions approved. And then immediately thereafter, enter into a public hearing and approval of the setting agreement. Keep in mind, these processes can be challenged. If someone brings a suit or tries to challenge it within 30 days, it's not final until that 30-day runs. There's some other provisions that are of interest in the agreement we don't have time to talk about today, dealing with assignability to third parties, whether it's with consent from the locality and an assumption of the obligations by the assignee. Having run out of time, I do want to take just a quick minute to talk about the next slide, the future in the General Assembly. As you may or may not know, back in the 2024 General Assembly, there were two bills, House Bill 636 and Senate Bill 567, that sought to establish a procedure to preempt local approvals by putting the approval in the State Corporation Commission. That would have actually preempted local authority. It was sort of a really aggressive approach and didn't move forward. The initial statutes or proposals wanted for projects, solar projects larger than 50 megawatts and wind projects larger than 100 megawatts or energy projects above 50 megawatts, we go directly to the State Corporation Commission for approval. Again, it was not passed. It actually got continued and put in a committee. It's being looked at by the new Commission on Electric Utility Regulation. So keep an eye on that. That's still out there and may come back in the future. A second bill that was introduced was Senate Bill 697, which the ban the bans bill. Simply the bill this bill would require locality to hear a project on its merits and then make an informed decision to either approve or reject. And what this would do is just get rid of all the opposition and obstacles and moratoria and the blocks that were occurring so that localities weren't even considering matters. That also did not pass, passed the Senate narrowly, but couldn't find a path forward in the House. So that also is being referred to and studied by the Commission on Electric Utility Regulation. And the last thing I'm mentioning is permit validity. This was HB 650. It establishes a minimum period of validity of 3 years for all special exceptions and conditional use permits for a solar project. What this did was to offer an extended runway to commence construction and get other approvals. It did pass both houses, 8610 in the House and 37-2 in the Senate. This will become new law July 1. It's unclear what this commission will do over the summer, so we'll keep an eye on that. And I think I've effectively run out of time. Thank you for your time and attention this morning, and I'll turn it back over to Brad.
Great. Thanks, Steve, for that. Before we get to a couple questions, I'll just mention that today's presentation is our second webinar. If you missed our April 3rd webinar, that covered a legislative update, just kind of following on what Steve was talking on. We've got a recording on our website, and the slides are also available, and the link is in our PowerPoint today, so you can access that if you've missed that program. We also have a number of other topics we're planning to cover during our webinar series, including the process for applying for solar and energy CPCNs from the State Corporation Commission. Prevailing wage and apprenticeship requirements are big issues for EPC contractors, so we're going to cover that. As Steve mentioned, we're also going to be covering Virginia state and local taxation for solar and energy storage projects. We had a presentation last year, but we're going to do an update on that. And then finally, we're going to have a presentation about covering key provisions on negotiating solar project acquisitions. If there's any other topic that you would like us to cover in a future webinar, feel free to email us, and we're happy to consider that for a future webinar. So let's get to a couple questions, Steve, just over a couple minutes that we've got left. What happens if a locality does not approve a siting agreement? Does that mean your project is denied from a land use standpoint?
No, it is not. In fact, the section 2316(9) basically says that the failure of the applicant and the governing body to enter into the siting agreement is a factor, can be a factor in the decision to deny your land use, but can't be the sole reason. So there's sort of a good faith provision in there that doesn't give you, a penalty if you fail to achieve that. What's interesting about that is, getting back to what I said, was the timing. When you reach that agreement and how you reach that agreement. That's why I encourage it to go on a parallel path early. Some developers want the kind of number to get out there so that incentive is known generally, and there's nothing wrong with that, and there's ways to do that as well.
Another question, I thought I saw that best projects are included in setting agreements, so maybe you can touch on our best part of the setting agreement statute. And then just a follow-on question is, how are payments viewed on BESS versus solar? I would assume the magnitude would be less per megawatt on BESS.
Yeah, that's been our experience, and I think the argument we've been able to make successfully is it consumes a lot less acreage because the batteries are more compact and dense, even though they might have a higher, high megawatt output. So I think the impact is much less, and that's part of the reason for the siting agreement, is to mitigate impacts. And if the impact's less, then obviously you would think the payment should be commensurately less. Repeat your first question again. I think I missed it.
Yeah, the first question was just to confirm that BESS projects are included as part of the setting agreement legislation.
Yes, they are.
Okay.
Yep.
Okay, let's just do one more question. Steve, can you just touch on a little bit more about the confidentiality and ensuring that setting agreements are confidential during the negotiation phase? The question relates to, what are concerns about getting community input on setting agreements if they're not confidential?
Yeah, I think going back to the concept that the setting agreement is a contract to be entered into with a governing body, and the financial terms are sensitive. Not every project is going to pay the same amount. There may be mitigating factors to why you would pay less. Let's say you had a project that was going on a brownfield and you had $50 million of remediation for the brownfield that had to be done in order to make that project work. You may go into the private conversations and say, I know last one you had in here, they paid you $25,000 a megawatt, but the reason we're giving you 18 is because we got $50 million of sunk costs to make the project viable. So, I mean, those kind of conversations are sensitive. They're valid, they're legitimate. I just can't see negotiating by committee. And then secondly, a lot of planning commissions are not organized where they have a focus point. You'll have 10 or 11 citizens, and they may all have a different idea as to what can go in a setting agreement, and they're really focused on how to spend the money. And that's okay. But I always say that's kind of behind the screen. We enter in a setting agreement, we legitimately reach these financial incentives, and then it's really up to the locality to determine how that allocation should occur.
Great. Well, it looks like we're out of time, so I appreciate everyone attending today's program. And Steve, thank you for your presentation today. If you've got any other questions, feel free to email us at energy@williamsmullen.com, or feel free to contact Steve or myself at the information on your screen. Thank you again, and we look forward to seeing you at our next webinar.
Thank you.